Hi, I'm Darcel and I own Dow Law Firm. I'm an attorney in the Seattle area, and today we're talking about non-intervention powers for a personal representative, also sometimes called a PR, sometimes also called an executor. But this is where someone's passed away, there was a will, probate is being opened, and one of the things, if you are I'm going to call them a PR just for ease for this video, if you are the proposed PR, you want to ensure that you have non-intervention powers. And so let's talk about what that is and why you want to have that. So the PR is the person who's named in a will to administer someone's estate according to the terms of the will. So the person's will says, I want this to go to person A, this to go to person B, and this to go to person C. Great. However, that is just a set of instructions. So how does that actually happen? How does everything get to person A, B, and C? It does through probate. Probate is a court process where a judge oversees the administration of the estate according to the terms of the will. So the court reviews the will, appoints the PR, the person that you have named in the will, assuming that they are qualified to act as PR. And then the question is, are they going to have full intervention or non-intervention powers? Okay. Most wills, if you had it prepared properly by an attorney, it should say that your PR has non-intervention powers. And so for non-intervention powers, that means your PR can administer your estate. Once probate is opened by the court and your PR receives letters testamentary, they can proceed to liquidate assets, pay debts, make distributions without having to go back to court for every step in the way. So non-intervention powers means the PR, the person who's named in the will and who's been appointed, the person who has letters testamentary, can administer the estate on their own. Okay? If you do not have non-intervention powers, then that means you have full intervention powers. Full intervention powers means the court is going to oversee everything you do every step of the way in a probate, which is kind of a lot. It slows things down. It gets pretty expensive if it's a full intervention. Okay, so if you are, filing taxes, selling a house, paying debts, closing out accounts, making distributions, everything that you're doing every step of the way requires a motion and court approval for you to take those actions. Whereas with non-intervention, once you're appointed, when probate's initially opened, you are off and able to administer the estate, and you're gonna give the court a final report at the end of the probate, but you're not having to go back to the court every time you need to do something in the probate. And so, again, most wills which are properly prepared by an attorney are going to provide for non-intervention powers. If there is no will, then it's not going to be such a for sure thing that you'll have non-intervention powers. And so if there is no will, you have to ask the court to give you non-intervention powers. If you are the one or whoever the person is seeking to be named as PR, has to get court approval to be have non-intervention powers. And so, if there's multiple heirs, they need to agree, the estate needs to be solvent. You have to prove that there is a valid basis for the court to grant you non-intervention powers as the PR of someone's estate. So again, with the will, that should already be provided for, so the court will follow the request of the will to have non-intervention powers. But if there's no will, you're going to have to ask the court for consideration to give you non-intervention powers. So that's really the difference, is having to go back to court to get permission every step of the way when you are administering a probate estate for someone. So I hope this is helpful, and I'll see you in the next one. All right, bye.